Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. This is my private Facebook group, and you can join us if you're in foreclosure, and we will help each other out. And today's topic is one a lot of people have been asking about, and that's where to start. So let's talk about where to start. Okay, where to start in foreclosure case. Okay, if you're facing foreclosure, the very first step is not filing motions or watching YouTube videos or buying a securitization audit. The first step is to examine your own loan documents and chain of title. Start with the promissory note, who it's payable to, and does it contain endorsements or allonges. An endorsement in blank, a special endorsement, or no endorsement at all each carry different legal meanings. Next, look for any allonges and determine whether they are properly affixed to the note and executed by a party with authority. Then review the assignments of mortgage or deed of trust recorded in the land records, or determine whether assignments are missing altogether. Pay close attention to dates, signatures, and whether the assignments actually transfer the debt or merely reference servicing rights. A foreclosure plaintiff must show an unbroken chain of title from the original lender to itself. Any break, defect, void assignment, or unauthorized endorsement can undermine standing and foreclosure authority. Understanding what these documents are and what they are not is the foundation of every legitimate foreclosure defense. Everything else comes after this step. QWR. The next critical step is to send a qualified written request, or QWR, or request for information to the loan servicer under RESPA. A QWR forces the servicer to identify who they claim owns the loan, who is authorized to enforce it, and what documents they are relying on. This is where many cases begin to unravel, because servicers cannot often produce a complete payment history, a valid chain of assignments, or proof that the foreclosing party is the current creditor. A proper QWR is not a debt dispute letter or a template demand for irrelevant items. It is a focused request for information and error resolution that creates a paper trail. It locks the servicer into positions and can expose standing defects, servicing errors, and foreclosure abuses early in the case. So here is a template, guys, if you want to look at it. They are out there, though, if you Google them. But you want them to be short and sweet, and you don't want to ask for everything, because then they won't respond at all if you ask for too many things. So here's what it looks like. It has your name and address at the top, the date. And you want to say it is a qualified written request under 12 U.S.C. 2605, 12 CFR 102435, and 102436, to whom it may concern. And it basically says this correspondence constitutes a qualified written request and request for information pursuant to RESPA and its implementing regulations. And then you say, I am the borrower on the above referenced loan. I am requesting information and clarification regarding the servicing, ownership, and enforcement authority of this loan. Please provide the following information and documents: the full name, address, and telephone number of the current creditor that you contend owns the loan, the date on which the current creditor acquired ownership of the loan and the manner in which it was acquired, a copy of the promissory note including all endorsements and allonges in the form relied upon by current creditor, identification of any assignments of mortgage, deed of trust, whether recorded or unrecorded, that you contend transfer an interest in the loan, a complete loan payment history from origination to present, including the application of all payments, fees, advances, and charges, the name and role of any servicers, subservices, or agents involved in servicing or enforcement of the loan, the basis upon which you contend you have authority to service the loan, and, if applicable, to initiate or pursue foreclosure. This request is made for the purpose of obtaining accurate information regarding my loan and resolving discrepancies in the loan servicing and enforcement history. Please acknowledge receipt of this request and provide the requested information within the time frames required by RESPA and Regulation X. All future communications regarding this request should be in writing. Sincerely, and then your name, your address, your phone number. And you want to send this via certified mail and keep track of when it was received and when they sent a response. They might violate RESPA, and you have evidence of this violation. You can use this against them to sue them. And then the next thing you want to think about is why you must audit your payment history. After reviewing the loan documents and sending the QWR, the next critical step is to audit your complete payment history line by line. Servicers frequently misapply payments, add unauthorized fees. They put forced place insurance improperly, advance charges that do not belong to the borrower, or credit payments late to manufacture a default. These errors can inflate the alleged amount owed, trigger wrongful default, and become the foundation for foreclosure even when the borrower was substantially compliant. A payment history audit can reveal missing payments, suspense account abuse, improper corporate advances, duplicated fees, and discrepancies between what was paid and what the servicer claims is owed. Just as importantly, a defective payment history undermines a servicer's credibility and can support defenses and claims for wrongful foreclosure, RESPA violations, breach of contract, and unjust enrichment. You cannot evaluate default, reinstatement, or cure without first verifying whether the numbers themselves are accurate. Now here is how to audit your payment history step by step. Once you obtain your full payment history from the servicer, you should recreate it yourself in a spreadsheet. Do not rely on the servicer's running balance or amount due column. Those numbers assume the servicer is correct. Your goal is to independently verify what you paid, how it was applied, and whether the servicer followed the note and mortgage. How to set up the spreadsheet? Well, you want to create one using Excel or Google Sheets, or if you have like Open Office, they have a way to do it there, or Microsoft Office. Anyway, you want to open up a spreadsheet and make your columns: payment date that you paid, the amount paid, how the servicer applied it to principal, interest, escrow, and fees. So you want a separate column for that. One for principal, a column for interest, a column for escrow, and a column for fees. What the note requires. In other words, monthly principal and interest, escrow, late fee terms. And then you want a column for the difference or error, and a column for notes. Then go line by line comparing. And you also want a date, by the way, in there, a date column. Because when you write your complaint, you can say on this date, this amount was misapplied for this reason. And that's a fact. So that's something that judges, when they see payment histories that are accurate and the bank is wrong, a lot of times your complaint will survive dismissal. So you want to do this. Look at your canceled checks, your online payment confirmations against what the servicer is saying. You're not looking for perfection. You're looking for patterns and discrepancies. And believe it or not, there's lots of these, especially if you've had your loan for many years. You're going to find this. Checklist: what to look for in a payment history audit. Missing or uncredited payments. Payments that you made that never appear. Payments posted weeks or months late. Payments held in a suspense account without explanation. Missing payments alone can invalidate a claimed default. Did you know that? Suspense account abuse. This is another thing. They did this with me as well. Payments placed into suspense instead of credited. Partial payments that were sufficient under the note. Repeated suspense used to force delinquency. Many notes do not authorize indefinite suspense holding. Improper fees. Look for property inspection fees, broker price opinions or BPOs, corporate advances, attorney or foreclosure fees added before foreclosure was even authorized. Fees must be contractually authorized and reasonable. Then you have forced place insurance errors, charges added while you had insurance, overlapping coverage, premiums far higher than market rates, backdated insurance charges. Forced place insurance is one of the most litigated servicing abuses out there, guys, and it causes people to go into default faster. Escrow manipulation is another thing. Escrow shortages manufactured by fee stacking. Escrow payments increased without explanation. Escrow advances added to principal or default totals. And another thing, they will take money out of your escrow account and pay something twice at causing default. I've seen that too. Late fee games. Late fees charged when payments were timely. Multiple late fees in the same month. Late fees assessed during active loss mitigation. Late fees are strictly governed by the note-in law. Default date problems. Default declared before payments were actually missed. Default date inconsistent with payment history. Default triggered by fees, not missed principal and interest. If the default date is wrong, the foreclosure timeline collapses. Reinstatement and payoff errors. Reinstatement quotes that don't match the ledger. Payoff amounts that include unearned interest or future fees. These numbers are often inflated and legally challengeable. Why this matters legally? A foreclosure case lives or dies on numbers. If the payment history is inaccurate, then the default may be invalid. The amount due may be wrong. The notice of default may be defective, and the foreclosure may be wrongful. Courts do not assume servicers are correct, but you can prove the errors. A clean spreadsheet ties to exhibits does exactly that. Why this work matters when you draft your complaint. The purpose of reviewing your documents, sending the QWR, and auditing payment history is not academic. It is how you plead facts, not conclusions. When you draft a complaint against a bank or servicer, courts do not accept allegations that a foreclosure is wrongful or that a plaintiff lacks standing without supporting detail. The note, endorsement, allonges, and assignments establish whether the foreclosing party is legally entitled to enforce a debt. A break in the chain of title, a void assignment, or an endorsement executed by an unauthorized party supports standing and authority claims. The payment history audit establishes whether a valid default ever occurred and whether the amount claimed due is accurate. QWR responses, or failure to respond, lock the servicer into positions and supply the factual basis for the RESPA, FDCPA, breach of contract, and wrongful foreclosure claims. When these facts are pled together, the complaint tells a coherent story supported by documents, dates, and numbers, making it far more likely to survive a motion to dismiss, and forcing the bank to defend the case on the merits rather than on technical pleading defects. A well-drafted complaint survives. Why a well-drafted complaint survives dismissal, guys? A foreclosure complaint that is properly formatted and carefully drafted is far more likely to survive a motion to dismiss because it presents specific factual allegations tied to documents, dates, and conduct rather than conclusions or boilerplate accusations. Courts dismiss cases when plaintiffs merely assert that a bank lacks standing or engaged in wrongful foreclosure without explaining why or how. A well-pleaded complaint identifies the note, the endorsements, and allonges relied upon, the assignments or absence of them, the claimed creditor, and the precise defects in the chain of title. It pleads payment history errors with factual detail, identifies servicing misconduct supported by QWR responses or non-responses, and connects those facts to recognized causes of action under state law and federal statutes. Clear headings, numbered paragraphs, logical organization, and exhibits references allow the court to follow the story without guessing. When a complaint pleads facts that are true, that if true, establish lack of authority or invalid default or statutory violations, dismissal is improper, and the case proceeds to discovery where the banks are least comfortable. Why surviving dismissal opens the door to discovery. Surviving a motion to dismiss is the turning point in a foreclosure case because it allows the case to move out of the pleading stage and into discovery where evidence is exchanged under the court rules. Before dismissal is decided, banks can rely on arguments and assumptions without producing proof. Once a complaint survives dismissal, the plaintiff gains the right to demand documents, interrogate witnesses, and require sworn admissions regarding loan ownership, servicing practices, payment application, and foreclosure authority. Discovery forces the bank and servicer to back up their claims with actual evidence. The original note, complete transaction histories, servicing agreements, and internal records, or to admit they do not have them. This is why banks aggressively seek dismissal early. Discovery exposes weaknesses that cannot be cured with legal argument alone. A well-pleaded complaint earns access to this phase where the cases are proven, not presumed. How discovery leads to admissions and summary judgment. Once discovery begins, the foreclosure case shifts to allegations to proof. Through requests for admissions, interrogatories, and requests for production, the bank and servicer are required to either produce the documents or admit under oath they don't have them. Admissions that the foreclosing party does not possess the original note, can not identify a complete chain of assignments, lacks records supporting the claim default, or cannot verify payment application errors are not arguments, they are evidence. Even evasive or incomplete discovery responses can support motions to compel and adverse inferences. When the material facts are established through admissions and undisputed documents, there is no genuine issue for trial, and summary judgment becomes appropriate. Summary judgment is not won by rhetoric on its own, not won by rhetoric. It is won when a record shows that the bank cannot meet its burden as a matter of law. Discovery is how that record's built. Okay, guys, I know this was kind of a long video, and it's kind of important that you understand these things, and it'll help you when you're fighting the banks. And so if you have any questions, you can always email me. My email address is the number 4, foreclosurehelp777@gmail.com, or you can leave a comment below. I hope everyone had a Merry Christmas and a Happy New Year's coming up soon. And everyone have a wonderful New Year. And hopefully you'll still be in your house next year as well. And as always, God bless.